Today, we will discuss some of the legal considerations for so-called synthetic equity agreements, such as phantom units or stock appreciation rights. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University, and I hold 4 degrees, including 2 law degrees, and a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Synthetic equity refers to incentive arrangements that mimic the economic upside of ownership without issuing actual shares or membership interests. Common structures include phantom stock units or phantom units and stock appreciation rights, sometimes called SARs. These awards typically deliver cash or sometimes settle in shares based upon the value of a company's equity at a future date. Companies pursue synthetic equity to align incentives with value creation while avoiding immediate dilution, shareholder voting shifts, or the complexities of amending organizational documents to accommodate additional equity classes. Despite appearing simple, synthetic equity is a sophisticated legal instrument with significant tax, securities, ERISA, and accounting dimensions. A phantom unit or SAR plan that omits a key definition, misprices an award, or pays at the wrong time can trigger severe penalties under Internal Revenue Code Section 409A, employee misclassification issues under wage laws, or unanticipated employer payroll liabilities. The decision to adopt synthetic equity should be made after a holistic assessment of entity type, governance constraints, expected exit path, and administrative capacity. In many cases, a properly structured plan can deliver targeted incentives without sacrificing control or requiring complex cap table surgery. But the path to that outcome is rarely linear and rarely simple. Phantom stock, also referred to as phantom units in the case of an LLC, typically mirrors full economic ownership of a unit or share, including both the underlying value and, if specified, dividend or distribution equivalents. By contrast, SARs generally deliver only the appreciation from a baseline price to a higher terminal value. The legal drafting diverges materially. Phantom units or phantom shares require careful definitions for unit value, dividend equivalence, and accumulated value, and those are all terms of art, while SARs hinge on the baseline or grant price, so-called, vesting conditions, and the specific definition of appreciation. A plan that confuses or conflates these mechanics risks overpaying, underpaying, or creating internal inequities that are difficult to remedy. Another distinction concerns settlement mechanics and taxation. Phantom units often function like deferred cash compensation pegged to the company's equity value, whereas SARs may settle in cash or shares or units based purely on the underlying spread. SARs that settle in stock or units can be friendlier from a cash management standpoint, but may introduce unwanted dilution as well as a complex overlay of securities law. Phantom units are sometimes perceived as easier to draft. However, they can be substantially more complex to administer because they demand periodic valuation updates and more robust definitions for events such as dividends, recapitalizations, and partial liquidity transactions. The right choice is context specific and requires professional modeling of costs, taxes, and accounting, operational, and legal impact. The feasibility and structure of synthetic equity will depend heavily on entity type, be that a C corporation, an S corporation, or an LLC taxed as a partnership. Subchapter S corporations face significant eligibility and single class of stock constraints that make certain phantom distributions or equity settled SARs problematic and untenable if they inadvertently create a second economic class. LLCs introduce separate complexities. Equity-like awards risk being characterized as capital or profits interests with unintended and sometimes unexpected tax consequences if the drafting blurs the line between synthetic and actual equity. For subchapter C corporations, synthetic equity is often easier to administer, but care is still indicated to avoid the many pitfalls under Internal Revenue Code Section 409A and to manage the optics relative to option pools and investor expectations. Governance and fiduciary obligations do not disappear simply because the plan is synthetic. Boards must adopt formal resolutions, establish a coherent delegation framework for grants, and ensure consistently that awards are consistent with investor agreements, senior debt covenants, and charter restrictions. Those will get you every time. Further, the board must consider the cadence and transparency of valuation communications to participants. Misstated or inadequately explained or disclosed valuation practices can fuel disputes, allegations of fraudulent misrepresentation, or even derivative claims. A narrowly tailored and thoroughly documented governance process curbs these risks and aligns stakeholders. A compliant program typically requires first, a master plan document approved by the board and, if applicable, by the equity holders. Second, individual award agreements specifying vesting, settlement, and forfeiture terms. Those are very important. And three, administrative rules and procedures that outline valuation frequency, adjustments for corporate transactions, and the processes for terminations. Boilerplate templates are usually inadequate. For example, a plan that fails to define cause with precision in the context of employment law will invite litigation at the worst possible time, such as immediately before a change in control. Similarly, failing to delineate exactly who has discretion to interpret the plan and what standard applies, for example, good faith determinations by the administrator, creates additional legal uncertainty. Board consents should confirm the plan's adoption, authorize the aggregate pool, and delegate authority to a compensation committee or designated officer with sufficient oversight to issue awards. In venture-backed environments, investor consent may be required under protective provisions. In family-owned or closely held businesses, owner-operators often overlook the need to harmonize the plan with buy-sell agreements, operating agreements, and loan covenants. When those documents conflict, synthetic equity holders can become unintended stakeholders whose rights are ambiguous precisely when clarity is indispensable. Vesting structures should align with business milestones and be rigorously tested against real-world scenarios. Time-based vesting remains the default, but adding performance-based vesting can enhance alignment if the triggers are objective, auditable, defensible, and drafted to avoid post hoc renegotiation. Companies must define whether vesting accelerates on a change in control, whether it is single or double trigger, for example, both a sale and a qualifying termination, and how partial year service shall be treated. Failure to specify these nuances can lead to disputes during acquisitions when counterparties scrutinize award schedules and may demand escrow holdbacks to cover potential claims. I've seen that several times. Forfeiture and clawback provisions require additional care. Define cause, good reason, and disability narrowly and consistently across employment agreements and the plan. Address garden leave periods, non-compete enforceability, which varies dramatically by state, and the conditions under which the company can cancel unvested or even vested awards in certain cases. You will also want to incorporate a clawback policy compliant with applicable stock exchange rules or investor-driven demands and specify exactly how recoupment operates for cash already paid. Omitting these details is not a cost-saving measure. It is a litigation minefield in waiting. Most synthetic equity is treated as deferred compensation under IRC Section 409A. To avoid penalties, baseline values for SARs and measurement methodologies for phantom units or phantom shares must reflect defensible fair market value. Private companies often rely on independent appraisals that create a presumption of reasonableness when performed under recognized safe harbors. While some businesses prefer management prepared valuations to reduce cost, and that is something we never recommend, such shortcuts can unravel under audit or transaction diligence if the process appears biased or inconsistently applied, as is often the case. Drafting must address corporate actions, splits, reverse splits, recapitalizations, and special dividends, just to name a few, and specify how award baselines and unit values adjust. Equally important is the valuation cadence. Annual updates may suffice in stable environments, but rapidly scaling companies, especially startups, or those raising capital, may require more frequent appraisals. Inadequate or stale valuations risk non-compliance, unexpected windfalls or shortfalls, and reputational damage during investor due diligence. Investing at the front end in a rigorous valuation framework is markedly less costly than rectifying 409A failures post hoc. Tax treatment hinges on the structure and settlement of the award in question. Phantom units and cash-settled SARs generally result in ordinary income to the service provider upon payment, subject to wage withholding and employment taxes. The employer typically receives a corresponding deduction at the same time. However, the timing can be nuanced. Certain awards may trigger FICA earlier, once amounts are no longer subject to a substantial risk of forfeiture, even if the cash comes later. Misalignment between plan terms and payroll processes often produces avoidable penalties and interest. Reporting also varies with worker classification and jurisdiction. Employees are usually reported on wage statements with appropriate withholding, whilst contractors may require different treatment. Some states, there we go, treat bonus-like payments as wages with specific timing requirements, which can interact awkwardly with deferred payment schedules. International employees introduce another layer of complexity, including treaty relief analysis, permanent establishment concerns, and the allocation of income across jurisdictions for mobile employees. That is another big one. The safest course is to model tax outcomes at grant, at vesting, and again at settlement, then map those triggers to your payroll cycles and cash forecasts. If that sounds like a lot of work, you better believe it is. Plans must specify the permitted payment events to comply with 409A, fixed dates, fixed schedules, separation from service, disability, death, or a properly defined change in control. Vague and nebulous language, such as when cash is available or at the board's discretion, is an audit magnet and risks immediate income inclusion plus penalties and interest. For private companies, the most practical event is often a change in control, such as a strategic sale or divestiture or an IPO. But delays and partial transactions, as are becoming increasingly common, increase the complexity by an order of magnitude. A carefully drafted sale definition should address asset sales, stock deals, mergers, recapitalizations, and earnouts. Liquidity planning is not just a finance issue. It is a legal issue with enforcement consequences. If plans promise cash on a transaction, but escrow holdbacks, indemnities, or debt paydowns reduce available proceeds, the company needs a waterfall that clarifies what employees receive, when, and from which sources. Consider whether to permit or require net settlement, whether to cap payouts, and whether to reserve a portion of proceeds for tax withholding. Payment mechanics that are clear and enforceable avoid last-minute fire drills, and renegotiations that compromise deal integrity and momentum and may expose the company to claims. Even synthetic awards can be classed as securities for federal and state law purposes. Private companies often rely on exemptions for compensatory grants, but these exemptions have limits and notice requirements. Failure to comply with Rule 701 type frameworks or state blue sky analogs can lead to rescission rights and fines. Documentation should address resale restrictions, acknowledgments, and legions for any equity settled SARs. For broad based plans, tracking aggregate award values and ensuring compliance with disclosure thresholds is not optional. ERISA concerns arise if a plan looks like a retirement vehicle or provides deferred compensation to a broad employee base without fitting within a top hat exemption. While most well-structured phantom unit and phantom shares and SAR plans avoid ERISA by tying payments to employment-related incentives and maintaining discretion, careless drafting can inadvertently convert an incentive into a welfare or pension plan with onerous and ongoing compliance obligations. Adding to this complexity minefield, state wage laws can treat promised payouts as wages due at termination or on fixed timelines, creating friction with 409A's rigid payment rules. Careful coordination prevents the unenviable choice between violating wage laws, violating securities laws, and violating tax laws. Cross-border workforces multiply risk vectors several times over. Local tax characterization, currency controls, currency exchange risk, securities registration, employment law, and data privacy are just a few of the concerns. A phantom unit payable on a U.S. change in control will be taxed differently in Canada, the United Kingdom, or Germany, with withholding and reporting obligations borne by local employers or by a global payroll aggregator. Some countries require prior filings or impose caps on certain compensatory instruments. Others treat equity-linked compensation more favorably than cash. Without a country-by-country matrix and local council coordination, a plan can trigger compliance gaps that are expensive to fix retroactively if they can be fixed at all. Mobile employees present separate allocation issues. When a plan participant works in multiple jurisdictions between grant and settlement, authorities may claim a share of the income based on sourcing rules. Plans should require participants to cooperate in providing travel calendars and to accept multi-jurisdictional withholding. Companies should also address data transfer mechanics when sharing participant information with valuation firms and administrators, ensuring compliance with privacy regimes such as GDPR. These matters are granular, and to be sure, they are tedious, but ignoring them is simply not cost effective. Synthetic equity has real financial statement consequences. Under accounting standards applicable to share-based payments, cash-settled awards are typically marked to market through compensation expense over the length of the service period, which can introduce income statement volatility. The volatility often surprises stakeholders who expected no dilution, no problem. Finance and legal teams must collaborate to forecast the expense profile under various valuation scenarios and to set expectations with the boards and investors. Although phantom units do not directly dilute ownership, investors and acquirers will treat meaningful synthetic overhang as part of the fully diluted picture. Transaction models often include an assumed net settlement or a reserve for planned payouts, which affects proceeds available to common equity holders. Transparent communications, including clear summaries of plan terms, vesting schedules, and payout models under likely scenarios for exit, help avoid mistrust and last-minute renegotiations. The earlier this alignment occurs, the smoother later financing and exit processes will be. Several common misconceptions persist. First, the belief that synthetic equity avoids 409A is simply incorrect. Most phantom units and cash settled SARs are classic deferred compensation and must meet strict timing and valuation rules. Second, the we can set the value ourselves mindset is particularly dangerous. Unsubstantiated management valuations are easily challenged. Third, the no securities issues exist because there is no stock is a misstatement which overlooks the reality that rights tied to equity value can still be considered securities. Finally, the whole we will clean it up at exit mindset ignores that acquirers price legal risk into the deal and may demand escrow or indemnities that effectively transfer the cost back to the sellers and employees. Common drafting errors include missing payment triggers, ambiguous change in control definitions, absence of clawbacks, and inconsistent definitions of cause and good reason across documents. Administrative missteps are equally harmful. Failing to update valuations, forgetting to withhold taxes on settlement, or paying outside permitted 409A windows. Each of these items is preventable with professional drafting, disciplined administration, and calendar driven compliance. The savings from DIY shortcuts or from relying on Grok or ChatGPT evaporate the moment a regulator inquires or a buyer conducts diligence. Let's talk about some special situations for just a moment. S corporations must preserve a single class of stock, so phantom dividends and certain settlement preferences risk disqualification if they create disproportionate economic rights. Plans should routinely be stress tested by tax counsel to ensure that payouts do not mimic a prohibited second class. LLCs face the opposite problem. Lines between profit interests and synthetic rights can blur, triggering unexpected partnership tax allocations or self employment tax exposures if the instrument is not clearly cash settled and separate from the equity structure. Tax exempt and governmental employers face Section 457F considerations for deferred compensation, which can cause income inclusion upon vesting rather than payment unless strict exceptions apply. Even when a form seems standard, applying it to a hospital group, university, or municipal entity requires tailored revisions. The practical implication is straightforward. Synthetic equity is not portable between entity types without significant recalibration by an experienced securities law and tax attorney and CPA familiar with the regulatory regime. Well-crafted plans address not only what constitutes a change in control, but also how payouts will interact with executive employment agreements, transaction bonuses, and severance. A double trigger design requiring both a change in control and a qualifying termination can balance retention with reward. Plans should clarify whether payouts are net of escrows, indemnities, and transaction expenses, and how disputes will be resolved if consideration includes earnouts or contingent value rights that are difficult to forecast or value at closing. Executives may face potential Section 280G golden parachute excise tax exposure when synthetic payouts coincide with other transaction benefits. Therefore, companies should consider cutback or best net provisions where appropriate and model thresholds long before a deal is imminent. Failure to anticipate 280G can force hurried adjustments that demoralize key talent or expose the company to additional costs through gross ups that could have been avoided with advanced planning. Some employers consider setting aside funds to ensure liquidity for payouts. While a so-called rabbi trust can provide some limited comfort, it must remain subject to the claims of general creditors so as to avoid immediate taxation under 409A Section B. Funding arrangements that undermine this principle can inadvertently accelerate income inclusion and penalties. Plans should clearly and conspicuously disclose that participants are unsecured creditors and that payment is subject to the company's solvency and status as a going concern. In distress and workout scenarios, synthetic equity holders sit behind secured lenders and general creditors absent explicit arrangements, and that would be fairly unusual if those explicit arrangements existed. Plan language should address proactively what happens upon insolvency, assignment for the benefit of creditors, or bankruptcy filing. Candid risk disclosure is both legally prudent and ethically sound. Overpromising availability of funds or suggesting guaranteed payouts invites claims of misrepresentation if the capital stack does not support such assurances. A realistic implementation timeline begins with stakeholder alignment, board, investors, finance, and HR, followed by term sheet development that captures objectives, target participants, and budget. Next, engage valuation professionals early and often to inform grant pricing and expense modeling. Draft the plan and award agreements in parallel with an administration memo that allocates responsibilities for grant approvals, record keeping, payroll coordination, and compliance calendar management. Before launch, rehearse end-to-end scenarios, a routine termination, a performance failure, and a change in control payout, including mock payroll and withholding steps. Those often fall by the wayside and they will come back to bite you. An effective checklist includes, among other things, confirming entity type constraints, harmonizing definitions across employment agreements, securing board and, if necessary, investor approvals, establishing evaluation cadence and sticking to that schedule, configuring payroll and reporting codes, preparing participant communications and frequently asked question documents, and scheduling recurring compliance reviews. Document every step. Regulators and acquirers prefer well-organized files over vague verbal assurances. The discipline of process is a value driver and differentiator, not a bureaucratic burden. Even the most vanilla phantom unit or phantom stock or SAR plan implicates multiple state and federal statutes, regulations, and accounting standards that do not forgive good intentions. A seasoned attorney ensures that the plan dovetails with corporate governance, securities exemptions, and employment law constraints, while an experienced CPA can coordinate tax, valuation, and financial reporting. This collaboration must be lockstep and prevents misalignments that are otherwise invisible until an audit or transaction exposes them. Cost concerns are understandable, but the SMART budget includes upfront investment in design and documentation rather than downstream triage. Fixed fee scoping for plan architecture, valuation, safe harbor analyses, and payroll integration is common and predictable, and it is something that our firm offers in many cases. The end result is a program that attracts talent and retains that talent, withstands diligence, and pays as intended and when intended, without penalties, disputes, or reputational damage. In matters of synthetic equity, precision is not a nice to have, it is the core of the bargain. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.